We are live and recording. Welcome everybody to the Ad Hoc Commission on the Discipline System ENEC Working Group. I will begin the meeting by taking the roll. Melanie Lawrence.
Here.
Ed Lear isn't here quite yet. Linda Schneider.
I'm here.
Wait, and Judge Wang.
Good morning. Happy New Year.
Happy New Year. Okay, so this meeting is to kind of summarize on the work that the ENEC working group has done and get prepared for the full ad hoc commission that is taking place next Tuesday. I will begin to share my screen. There's just a short PowerPoint of previous PowerPoints that to make sure that we're all on the same page. So can everybody see my screen? Okay. So the agenda today is to review the ENEC changes that we talked about, criminal conviction cases. The working group has two proposals for criminal, well, not necessarily two proposals, but one proposal adding the ability for criminal conviction cases to go through an ENEC process. And then we have also talked about limiting the number of ENECs. And we also had at our last meeting, Linda was nice enough to provide us with a proposal on extending the timelines, but the ultimate discussion around that, there were concerns from the working group. And so that proposal was ultimately not adopted, but there was a robust discussion on it. With regards to the criminal conviction cases, as a reminder, a lot of this came about because of the Corey cases, the re-fingerprinting of the attorneys. This isn't totally done, but we've got through a majority of the Corey cases and they will resolve themselves. And if you remember in the discussion that the ENEC for C cases would impact very few attorneys. I don't remember the exact amount, but I think it was around like 3 or 4 attorneys that are non-Corey cases that would be impacted by the C cases. And Ed, who isn't quite here yet, said that that was enough to potentially make a change of that. And as a reminder, there is the timeline crunch is the B&P code that requires the transmittal within the 30 days. So this is why there isn't currently the way the business and profession code read the ability to do an ENEC for C cases because there's just not time. We have to transmit it, and once it's transmitted, then it's public, and that's the benefit that the ENEC for the C cases, if it was adopted, would be that it wouldn't be public. You would be able to go through that ENEC process with the C cases outside of the public. So the proposal, I think, I will talk with Ed once he joins us here, but would be to either, there are a couple avenues that we could go about changing things. One would be excluding C cases from this statute or extending the timeline, or there's a couple of different ways. And I don't think that the committee necessarily has to get down into the nuts and bolts and how we implement this. It just can be a proposal that a more broader proposal, and we can kind of work with our stakeholders and other people to see the best avenue to make that happen. Are there any questions or concerns? Are we all on the same page with C cases?
Good morning. I'm sorry I'm late. I do have a question. And
yes.
Question generally is, when you say we don't need to get into the nuts and bolts, that I suppose that's nice to hear. In terms of our responsibility, is the goal then for our subcommittee to make our working group to make a recommendation to the committee at large with respect to, for instance, extending the timeline and excluding or excluding C cases from ENECs, and then having the full committee vote on that? Is that the protocol?
Yes, we're eventually going to make the proposal, and since the working group has discussed this extensively, I will turn to the working group as to why they think this proposal is worth it. What I meant by nuts and bolts is there are a couple different ways. And so we can propose this is where we think it is, but the goal is to have ENEC, the ability to hold an ENEC for a C case. And so I don't know that the proposal has to be that in depth. We can say that we just want ENEC, the C cases, to have the ability to have an ENEC before they become public, because that's what the goal of that proposal is.
Well, let's just say hypothetically, and maybe it's not so hypothetical, that our working group does not agree on that. Then I'm guessing that that's where this is going. And so how I foresee this, and I'd like to have people chime in, is that we would present to the committee or the committee at large that we have worked hard on this. We have become educated. We have done our due diligence, and these are the conclusions, or at least the perceptions that we have. And maybe I advocate for one side, Melanie for the other. We've done that before. And then we present that to the committee, and then the committee votes and majority rules. Does anybody think it'll go a different way than that?
No, that is the plan, because there wasn't consensus on this one. I think it was split 2-2. And so and this isn't the only working group that doesn't have unanimous recommendations. There are other working groups that have differing recommendations. The expungement working group has is much different recommendations, and the working group is because the commission as a whole is 23 members, this is a very small part of the commission. And so the fact that we don't have unanimity here is okay. And so the plan is to present both sides to the full ad hoc commission and have them weigh in, basically vote, and majority does rule as to what will be included in the final report.
Okay, and then thank you for that. And in light of that, can we talk then? I don't know what your agenda is today, Justin, and I don't mean to interrupt and knock you off your agenda, but I am curious as to whether we can and should talk about where we do agree, because I think that's important as well. And or do we need to trade horses here and come to a compromise so that we as a working group are able to present a recommendation rather than we can't agree, let's toss it up to a vote. What does everyone think about that?
And you're not throwing off my agenda at all. This is mostly summary of where we're at and just finalizing how we're going to present to the committee. So this is perfectly falls in line with what I had intended for today's meeting to be.
And prior to comments, Justin, if you could just refresh everyone's recollection as to what the 2-2 vote, what exactly we voted on, because I don't have an exact recollection.
Well, it was basically the premise of, do we change the rule, either the statute or the rules to allow for an ENEC for criminal conviction cases? And I don't want to summarize, but the vote was basically, it's not going to really impact, because we get through Corey cases, it's a relatively minor amount of people that it would impact. So is it worth changing the system and changing these things? Because there are conditions that the ENEC, there's work that's involved with this, there's other things. And so it was just whether or not it was kind of came down to worth changing the system for. And I think that's where the vote was, but the working group members are here, so I will be quiet and let them talk.
Does anybody see what we voted on any differently than that? Is it just change versus no change? Is it that simple?
Excuse me, I think so. I think Justin summarized it pretty well.
Okay. Judge Wang, how did you vote?
I don't recall voting. I recall talking about different ways of thinking about allowing for ENECs. I had proposed kind of something in the middle, and I don't want to call put Linda on the spot, but I think, I don't think there was a disagreement that we can retool it if it doesn't change the timeline. That was sort of my feeling of it, but I don't know. I mean, I don't want to put pressure on any any particular person, but I don't recall getting that detail to Justin in terms of voting about any particular change. But where I stood was, out of fairness, regardless of how many numbers of participants ended up in a dismissal or a private removal kind of condition, I don't see the issue of holding an ENEC during, if we're keeping the timeline. But,
Melody, do you disagree with that?
Well, I guess initially I feel like it's too few people that we're talking about to expend the resources on it. That said, if we were going to look at changes, and I'm just talking about related to the C cases specifically, I personally don't think that we should be looking at advocating for a statutory change. I don't think that that's time or resources well spent. So I think the question would be, and perhaps this is what Judge Wang was referring to, perhaps there would be some rule changes that could be made. I don't know what those are. I think that those would take some study. But again, I mean, overall, I just feel like it's too few cases. The whole goal of ENECs is to resolve cases before they're public. In most instances, conviction matters are public in any event. So given the number of other things that the ad hoc commission is looking at, I just don't think that this is a place where we should be spending our time.
Okay, and you can guess that my position is one is too many. But Linda, what do you think?
Well, I was opposed to a change. Number one, I think, as I have learned, the ENEC process is to evaluate cases to determine whether or not they're meritorious. And when you have a criminal conviction, you really already have that. And I imagine that's the reason that it was set up this way in the first place. There's already been an adjudication. So it's a different kind of a situation where you have a batch of facts and whether or not they're true or not, and how they fit within a statutory scheme. And secondly, it's an issue of administrative economy, to be able to put in a bunch of ENECs where they have not already been established by the legislature. It just slows things down. We've already learned that ENECs greatly increase the amount of time for processing cases. And once you've had a conviction or an adjudication has already occurred, I don't see the value of adding ENECs to that. So I was opposed to a change.
Okay, and I just want to respond to one comment because I do disagree with at least one part of what you said, which is I don't look at an ENEC as being a determination as to whether a case is meritorious. Let's just say I agree that a case is meritorious. I think that the distinction is between public discipline and private discipline, and giving the opportunity for certain respondents to have what we call a private versus a private approval versus a private approval with public disclosure. So that's always been my focus. I've never said that these are not meritorious matters. There may be some dismissals in there, sure, and that happened a lot in the fingerprinting era. But and a dismissal is a dismissal, whether it's a filed action or not a filed action. So we're not talking about that either. I do concede, based on the metrics presented by Ron and potentially Dag, that there are not many cases that we're talking about. But again, one is too many. And so I also challenge the comment that this would create well, nobody said it this way, but great new expense. In my mind, the judge is already there. I understand from Melanie's point of view that there needs to be an accelerated workup, and I'm assuming that that's part of what the additional resources would need to be used for, but that's workup that will need to be done anyway. So maybe I need to be more educated as to what the additional resources would be if we had additional ENECs for criminal convictions. So I do need help with that.
Well, when I was talking about resources, I simply meant, our time and energy and resources of this working group and the commission in and of itself, given the number of other items that are being discussed. But that aside, I mean, it does seem to me that I think this is what Linda may have been getting at. If we're adding ENECs to the court's calendar, that inevitably is going to increase the need for judicial resources. I don't know how many of them would avail themselves of that opportunity, but we heard from Judge Wang that the court's calendar is rather full with a number of other items. And so now you're only adding more to the calendar. And I'm not sure, again, that it's worth it in the end.
Well, I don't think we did this metric, and I don't think we need to, but Judge Wang can speak to this. If you resolve a case at an ENEC, then that case is not making it into the regular track and cluttering the court's calendar.
Right, and now it's what I think we're just at an impasse, frankly. And I don't mean to sound frustrated, but what I was emphasizing with Ron's stats is the picture that we don't see in it, and what Melanie just raised. So again, when cases are filed, we're all looking at the 125-day date to begin trial. So my point is, if we can resolve some of the C cases that before it even hits that mark, that 125 mark, you're alleviating the calendar from the back end. And I understand Melanie's point is that, well, maybe the issue should be we retool the deadlines on the back end versus, messing with it at the front end. And that's why that's her perspective. And that's the court's, what my perspective is about what I've called the bottleneck. So, for the overall health of the system, that's why I feel that putting in an ENEC phase for the conviction referral cases, if it doesn't affect the timeline or the statute, OCTC would still report it within 30 days, but it stays when the review department refers it to the hearing department, they're referring it to the hearing department for an ENEC. And frankly, I think that's to OCTC's benefit too, because when I'm holding these settlement conferences on the criminal cases, OCTC is like, well, there's no mechanism to propound discovery. There is, you have a duty to cooperate. I know OCTC's looking at perhaps expanding the process for criminal conviction cases to allow for a deposition of the respondents. That's not in the rules of procedure. So I think realistically, OCTC does need a small period of time to investigate, to do what's right. And so that's why I'm a little bit perplexed a little bit why we can't kind of accommodate both interests. I think both sides need a little bit of time to investigate to see what is provable and what's not, because the difference, and I respect Linda's perspective that this information is public anyway, but yes and no, are people really going around looking for whether or not the attorney they want to hire has a DUI from 10 years ago? I mean, I think at some point we have to balance, what the public, should know and needs to know versus kind of like this situation where, it may resolve and it may not be public. So as a neutral, I can see it from both sides, but it just,
there's also,
is.
sorry, we're forgetting something else as well. So I agree that I'm the one most guilty of this, and I'm talking about the privates, but there's also the situations of criminal convictions settling for something that is public discipline. And so the advantage of an ENEC, of course, is the respondents' cost and legal fees, costs in the state bar cost assessment, time, emotional distress, everything else that goes along with going through the prosecution by the state bar in a full proceeding. And so that's what we do in every other case, in O cases and whatnot. There are cases that settle at ENECs for all of those reasons, cost, and just getting the appropriate result at an early level. So I don't want to lose sight of that too, because I think my clients, not frequently, but we settle cases at ENECs, hard cases that are public discipline cases. And so I think the position of there are too few to expend resources is legitimate in the context of criminal convictions that result in privates. Okay, I know that's not many, but there are others that would settle at an ENEC that would reduce administrative expenses to the state bar, would reduce costs to my clients, would reduce emotional investment in a case to my clients. And for many reasons, I think it would declutter the system. And maybe that's the way we need to look at it. Does anybody have any comments about that?
I mean, we can settle cases at any stage. And there's a settlement conference that occurs in the context of C cases. We don't even require going to an ENEC or a settlement conference in order to settle cases. We're happy to talk about settlement of cases at any time. If the issue relates to costs, I mean, that's a whole nother issue. That's, costs are set by, I think, the Board of Trustees. And if we're concerned about costs, the later we get into the system, that's another discussion to have. But again, when we're talking about ENECs, it's an early neutral evaluation conference. It's not a settlement conference. Although the reality is that sometimes cases settle at the ENEC stage, but that was never the intention of the early neutral evaluation conference to begin with. The issue really does relate to resolving cases potentially without public discipline. And in most instances, C cases are going to result in public discipline. So, I mean, could the system overall be more efficient? I'm certain that it could, but I go back to this issue of, once the case is public, whether you're talking about an O case or you're talking about a C case, the timeline that the court has, it's very abbreviated. And perhaps that is something that we should take a look at if that's our concern.
Okay, well, and Judge Wang will love this one, but there is value to ENECs to my clients, because when Ed tells them it's a 60-day actual case, that may not be good enough for them. But when I walk into an ENEC and the judge says it's a 60-day actual case, that case resolves. And yes, I agree that I can pick up the phone at any time and talk to a DTC and potentially settle a case. But at least in my experience, the ENEC does help because I don't always have clients that agree with me. And so when I have a judge who says, yeah, or sometimes I'm wrong, and the 60-day case that I think it is, judge says it's a 120-day case. And so that helps inform me to inform my client. So there is value. And that's not just my O cases, that's my C cases. And we all, I think, probably all agree that with C cases, it's only a level of discipline issue, because the elements of the crime are presumed to have been proven. So what are we really doing other than putting on mitigation and then arguing the level of discipline? So it's actually maybe more perfect for an ENEC than any other type of case.
Well, I'm not sure I would agree that it's just a level of discipline. Certainly that is one of the elements, but what drives the level of discipline is the facts and circumstances, and whether or not the misconduct is moral turpitude, which is potentially an issue for the respondent to stipulate to, or other misconduct warranting discipline.
Okay.
And I also just go back to this idea of we have 30 days, and the reality is that, I mean, I don't even know how logistically this would work, given the fact that the challenges that at least that we feel like from OCTC's perspective, when it comes to ENECs related to other cases, is the length of time that it takes to get in for an ENEC and the continual rescheduling or extending ENEC opportunities, to me, there's a disconnect because there's a frustration that we have with that. And yet we're talking about somehow we're going to manage it within 30 days. And the two don't go together to me.
Well, what about Justin's comment about extending the timeline? What if it was 60 days?
Are you talking about related to the statute?
Yes. Oh, but I don't want to mess with the statute if we can help it.
Well, I mean, I don't know how, when you're talking about literally extending the deadline is set by the statute.
What if there was, and I don't know the logistics of this, but if your office had a policy, not a rule, not a statute, that they would afford criminal convictions and ENEC opportunity. I don't know how we would do an end run around the statute. I think Judge Wang came up with that one at one point, where we leave the statute in place, because that's a big job. And if there's some way to craft a rule, or I guess excluding C cases would also maybe be a statutory issue. But if there's some way that OCTC could have a policy to afford criminal convictions and ENEC, somebody help me with this. I'm not articulating this very well, but something that where the statute would not be in play, but there would nevertheless be an opportunity afforded to respondents to have an ENEC for a criminal conviction on a extended timeline. Now, okay. Wait, so Melanie, when a criminal conviction comes in, before it's so does the timeline start when it's referred to the court? No, okay, sorry, withdraw that comment.
Yes, because the 30 days, this is what we talked about it. So once OCTC transmits the a conviction to the review department, becomes public. That was the issue.
Right.
So I had suggested at one point, I believe, is to track, I have to pull up the two provisions of the Business Professions Code, but to track the 6101C language with the O cases, because the O cases doesn't become public until the filing. So the idea was that just because they refer to the review department, it doesn't become public at that point. And the review department, because our orders from the review department is to hold a hearing. If the referral could be hold an ENEC, then that would kind of be the workaround. That was one of my suggestions at some point.
Right, so I like that. So prior to the referral from OCTC, that would be the window in which nobody would have to deal with the statute, if I'm understanding this correctly, because it's not a publicly, well, I think. So if OCTC became aware of a criminal conviction, they plan to refer it to the review department, but prior to the referral, there's a window of opportunity to have an ENEC without the statute coming into play.
I think that that's not right, but I would have to look at the language of the statute. But it's basically, once we have the certified record of conviction, that's when the 30 days starts, when we have to actually then refer it to the review department.
Okay, thank you.
It's playing with the public language, Ed. I think that's what I suggested. Because under an O case, it doesn't become public until it's filed. So in some ways, when you're referring it to the review department, you're not filing it, you're referring it to the review department, because technically the review department could dismiss it, but they never do, right? If it's final, they refer to us, but technically they could dismiss it. So in my mind, it's not really filed until the review department orders the hearing department to hold a hearing and to generate, whatever, a notice of hearing. And then the respondent has to respond to the notice of hearing that the court generates. They're not responding to the transmittal. They're responding to a department order. So that was kind of the idea that I was floating. And then in that time period, OCTC can do the depot, they can investigate. Frankly, it could get worse for the respondents if we propound it that way, to be honest with you, Ed, because oftentimes it's the facts and circumstances, as Melanie pointed out. And I think that's kind of the frustration, at least from their end during VSC on the criminal cases, is, there isn't a deposition, there isn't, same type of exchange of discovery that you see in an O case. And sometimes, frankly, it gets worse at trial than it would have at an earlier stage. I mean, it cuts both ways. But I think both sides see the limitations of the way the rules of procedure operates now in conviction referral cases. The question is, what direction do we move it to make it better for everybody?
Right. So Melanie, hypothetically, if OCTC had 60 days after certification of the record and prior to referring it, would that change your view? I mean, not change your view. Would that give your office enough time to work up the case for purposes of an ENEC?
I'm not quite sure what you mean when you say work up a case for purposes of an ENEC.
Well, did I misunderstand you? I understood at some point that you said that 30 days was not enough time for your office to, and I use the term workup, I don't know what you used, in order to have a meaningful ENEC.
No. When I said that, what I meant was that I just logistically speaking, given what we observe with O cases, that it doesn't seem to me to be realistic that our office and counsel for the respondent or the respondent can agree on a date that the court is going to be able to get us into. We've had conversations about how long it takes for documents to be filed and the court to have a meaningful opportunity to take a look at the documents. Oftentimes we get into ENECs and they get continued, or we're ordered back for multiple ENECs. That's what I'm talking about. That the disconnect for me is that when we are already struggling with those issues related to O cases, it just doesn't seem reasonable or practical that in C cases, we're going to manage to accomplish all of that within a 30-day timeline.
Okay, so here's where I'm coming out on this, and everybody help me with this. This is a really robust colloquy that I'm enjoying a ton, and I hope everyone else is. I agree that we're not really convincing one another of our respective positions. And how do we condense this for a presentation to the commission, or do we? Do we just let it ride like we're doing right now? Let everybody hear our respective positions and let them vote? What do you all think? And Justin, how much time are you allotting for the discussion about this issue for the big meeting?
The big meeting, I just put roughly like an hour of discussion, because you've actually held probably like 6 working groups on this discussion. And so to condense it down, but it can take less, it can take more. We're kind of, the meeting is 6 hours and we have 5 working groups plus a separate presentation that we're discussing. So I've kind of allowed it like an hour roughly for this kind of presentation.
Well, so one way to do our hour may be just to do what we've just done here and have the 4 of us articulate our respective positions and let people be informed, because I think that I have been more informed from this working group than I was before the working group. So I don't think my position has fundamentally changed, but I am more respectful of the other side's position, and I'm more informed with respect to making the arguments that I need to make. Does anybody disagree that the 4 of us should just do a free form?
Well, I think we'll frame the presentation with some of the numbers that helped get us there, so we can see the numbers of the ENECs, the number of ENECs that have taken place and, remind people of the statute. But then, yes, I think that it's best, I would turn, that is my plan, is to turn to the working group members to make the case.
Justin, I think we covered so much. I don't know if it makes sense to do an outline and just have pros and cons on like a one sheet. And, again, I'm a neutral. I know I've been kind of all over the place because I am, but I don't really feel like I, as the judge, should be making a particular presentation. But the
Oh my
ideas
God.
that we talked about.
I just lost a vote.
No, I'm just saying I don't, I don't want to appear as if I'm advocating for one thing or the other. If we can present like a one sheet where no one's called out necessarily, and it has the pros and cons, I would feel more comfortable in that type of presentation. But
we can definitely do that, and I can lead it off with the question, what we're trying to solve, what we're trying to get, and then the pros and the cons. That's definitely a summary statement that we can provide and lead off the discussion.
Yeah, I agree with Judge Wang. I think it would be better introduced like that. And I mean, obviously we'll be there, and if people have questions, we can chime in, but I think it would be a bit much for four people to basically give their potentially opposing views on this topic.
Right.
I don't know how they're going to make a decision. Yeah.
We're not doing a Lincoln Douglas debate. Yeah.
Linda, what do you think?
Well, frankly, it seems odd to me to put a proposal to the larger group when this group has spent many hours in discussion of it and knows it well, and then send it up to people who really don't know the issue in any depth and ask them to decide it. It seems like an odd way to go to me.
What do you suggest?
I wouldn't advance a proposal to the larger group if there's not a proposal that's been determined by this group. That's what I would suggest. I think it makes more sense of having the most informed people make a decision and then have the group decide whether or not to accept it, as opposed to having a group that has less knowledge actually make the decision.
Well, I think we all agree with you, but we don't have a consensus. So we've got that. And I think we need to report that we don't have a consensus.
Justin, I guess what I wonder is, do you know what other working groups are doing that don't have a consensus?
Well, we're basically providing two sides. The working groups, this working group in particular, was people with, kind of specific knowledge of the system, but other working groups were just volunteers. And so we're not going to get, they weren't necessarily balanced. And as we went through the discussions, we knew that they weren't balanced because we're trying to vet the issues and simplify it down to the word. It's not perfect. I'm not saying it's a perfect process that we're going through, but that's why we've kind of taken these working groups, because some of the other, there's definitely like expungement. There's definitely two sides to expungement. There's, the discipline defense counsel side, where they look at it one way, and then there's, the OCTC side that looks at it very differently. And what you get is you generally get where the arguments are, you talk about lots of different arguments, but then you kind of home in on the main arguments, and that's what you're going to present. I mean, this commission is, 23 members. And so we had to pick one way, and this is the way the paraprofessionals had kind of gone about it. And so the other working groups, because they aren't balanced in their representation, we are presenting both sides, but we're trying to condense it down to these salient points. So we're not having hours and hours of discussion. We're saying we had hours and hours of discussion, and this is what came from that discussion is they proposed this, and this is why, and they proposed this, and this is why. Is for the bigger, larger working group to ultimately make a decision.
Okay, so we've agreed that we have an impasse. Linda has said that since we have an impasse, she's not in favor. I want to be careful of what I say here, that You think as a result of the impasse that there is no proposal, and we have nothing to present to the committee at large. I disagree with that. I think that we owe them at least a discussion as to what we've considered and why we have an impasse. And then I'm in favor of letting them vote, however it comes out, as to whether they're in favor of ENECs for criminal cases. And I understand, Justin, that is the extent of our working group, ENECs for criminal conviction referrals.
Well, the other piece that was talked about that we haven't talked about yet was the limitation of the ENECs. We had talked about limiting the ENECs to one ENEC if the ultimate outcome of the discipline was going to be public. I think that's what Melanie kind of made the pitch for. And so that could potentially be the other thing that came out of this working group that I was going to get to after we talked about this initial thing.
Okay, can we take a preliminary vote on that? I'm not in favor of limiting ENECs to one.
I'm in favor of limiting ENECs. I don't know if I don't think it's as black and white as to one, but my point was that if the court, something to the effect of, if the court after an ENEC finds that the matter would could potentially resolve with something that is not public discipline, then potentially, there could be another ENEC. But in cases where it's clear that the resolution is not going to be something less than public discipline, I don't think that we should engage in multiple ENECs.
When I feel comfortable weighing in the separation of powers issue. So I would oppose anything that would limit the court's discretion. So that one I can neutrally advocate against.
Linda?
I'm in favor of that proposal. I think one ENEC is completely appropriate to evaluate whether or not a case should move forward for those few cases where public discipline is not appropriate. More ENECs, but the whole process is getting bogged down with these ENECs that occur before even public filing. So I think it's it hinders public protection to have ongoing ENECs, and we know that the more and more ENECs just draw out the timeline. So I'm in favor of Melanie's proposal.
2-2.
Hello, I'm just calling to see if you needed it.
Okay, so 2-2 again. And I suppose we could just present this to the group and let them know, and we can articulate our respective positions. So Justin, those are the two issues we have for our work.
Those are the two that I have that we were going to present to the full commission.
Okay. Okay, so I think we're in agreement that we disagree, which is fine. And I think that's the way we started, and here we sit. And that's okay, because we've really worked hard, and we'll be able to educate our brethren as to our hard work and our thoughtful analysis and our respective positions. Justin, what are you recommending as the most effective way for us to present during the hour that we have?
Like I said, I will put together from previous PowerPoints just some framework of the numbers, so they can get an idea of the numbers, because I think the numbers help guide this, particularly around the number of ENECs with the Corey case piece, and then also just the number of ENECs for the second topic on how many are multiple ENECs and settlement rates and things of that nature. And so we can present that that presentation to kind of get them, and then talk about this discussion. I'll turn it over to the working group to actually have the discussion and not present your argument, but that's essentially what you're doing as to why one should be adopted.
And Justin, who is, are you emceeing the event? How's that going to be? How's that going to be?
I will be hand in hand with it because it's a full ad hoc commission. The chair of the ad hoc commission, Brandon Stallings, will be chairing the event. And I met with him going over the agenda and telling him kind of what we're doing. And since we will be having another full ad hoc commission meeting in late February or early March, if there are, if the discussion, if people aren't comfortable or they want more information that we just hadn't thought about, we have time to, postpone it till the next meeting if stuff arises. There is not a firm deadline that they have to make these decisions on Tuesday. We will have another full commission meeting where we can discuss it as well.
Okay. I have to hop. I have 200 attorneys to whom I'm speaking at 9 a.m. about putting on evidence at trial. And I'm getting the hook here. So I apologize for that. I just want to make sure Melanie's not going to put anything up to a vote once I get off. Kidding. Okay. And Justin, with that, I mean, is there anything else that you need me for?
No, I don't. Unless the working group members have anything else they want to discuss, we've discussed what I wanted to accomplish today.
Okay, I think this was a really good meeting. So thank you, everybody. I think it was effective and everybody articulated their positions really well. So I think we had a nice working group. I think it was effective in achieving what it needed to achieve. Ron and Dag and Lisa, thank you so much for all the hard work. And Ron, your metrics were really, really insightful. I thought that it really helped drive the discussion. So I appreciate all the hard work you did on that. So with that, I'm going to sign off. Goodbye, everybody. And I look forward to seeing everybody next week.
All right. Thanks, everybody.
Thanks.
Thank you.
Bye.
Bye.